work consistent with it. Collaboration with disability advocacy groups can provide invaluable insight and guidance on respectful and accurate portrayals, ensuring that content aligns with the lived experiences of persons with disabilities. And then we have referred to training and sensitization programs. So we've laid down a comprehensive framework of hopefully what portrayal in the visual and electronic media should be like, without infringement on the right under Article 19(1). Thank you very much for your assistance, everyone.
It's a path-breaking judgment. You are the petitioner. I am privileged to be a part of this judgment.
Thank you for your, you also made your submissions and for the hearing. Thank you very much.
Thank you so much for this. Thank you.
Much of this. May I crave my Lord's indulgence on this?
Yeah, yes.
Manish Sisodia's matter, he's been there 16 months in jail. The court said trial must be near conclusion. It hasn't started. I filed the SLP. They gave liberty after third. The Supreme Court gave liberty to list it.
On Saturday, so the defects will be cured. And
it's a revival because the court said you just keep it in abeyance, revive it. Lordship, kindly look into it.
I'll look into it.
You've given the email. No second matter, I'm not troubling Lordship, is showing 23rd. The second matter, 23rd is showing just now. So we'll just say not to delete. There's one more.
Just see what it is. Have you sent an email?
Yes, yes. It's here.
I'll attend to it the moment we write.
It's already showing 23rd in the second matter. So it's just not deleting it.
If an email is sent, and I say not to be deleted. We have I even have a code. I call it NTD, not to be deleted. So we'll do that in the
article. I have a question, Milords. We have circulated emails. Now, this is a matter of some urgency. Your Lordships have issued notice. There's an interlocutory order. The matter is now for final disposal, my main appeal. But there's a need for urgent further interlocutory relief because I've been outflanked. I don't want to take
it. Make sure that I'll...
Could it come up on Monday, Milords, next Monday?
Yes, I'll immediately attend to it.
I'm very grateful.
Yes, not in a matter, Milord, where I had, if urgency, I had moved, Milord, the vacation too. Milord, the Lordship said that I have to move the learned Chief Justice first, which I have done. I sent him, Milord, I made a mentioning memo. Now, Milord, apparently, 2 out of the 3
I think all requests by Saturday evening. If there's something which has remained, I'll do it today itself.
It's just that, Milord, that we move the registrar said the orders of the Chief Justice are required. It's now listed on 12th is the day, Milord. All that we pray for is that it should not be deleted.
I'll look at it.
Yeah. It not be deleted, Milord. That's all.
Let me just see what it is. I'll process it the moment we rise.
As a 30-mile petition filed by 6 students from Gujarat, we are praying that the Neet exam should not be cancelled. The Neet matter is coming up at item 31 today.
That's all I just mentioned when the matter is.
Very well.
Yes.
Very well.
May I say the Lordship? Yes. Lord, a TV channel in Bangalore has paid from broadcast completely last Wednesday. 5 days SAT, the diary number we mentioned in the registrar this morning, but it could not be mentioned earlier.
Just circulate an email. Just circulate an email. It will be listed, but just when was the email sent? So then why do you not have to mention?
This morning.
I'll pursue it in the afternoon.
Wednesday.
Don't worry. It will be attended to today. It will be attended to right away.
One lady petitioner, she is a widow. If Madras High Court granted bail, there was certain conditions, the cheat fund. Her husband committed suicide because...
Circulate, Mr. Mishra, circulate an email. I'll do it.
They are going to take custody.
Send an email. The moment I rise at 1 o'clock, I'll attend to it.
That listing registrar has allowed it in the morning today.
All right. Just point it out to me. We'll immediately I'll attend to it.
Milord, my case was in the advance list tomorrow, but not in the main. Milord, lord, my case
This
was.
matter pertained to Justice Bopanna's roster.
Yes, my lord.
The registrar informed me I've already reallocated it to another judge. Now that Justice Bopanna is retired, it will come up next week. It's coming up next week.
Lordship, similarly, this is the case, again, in the advance list, this is with respect to the rights of people with wheelchair, the SOP at airports. That learned SD has said he's ready to cooperate. It's just been coming but not listing. Ever since.
Just circulate an email, I'll immediately list.
Thank you so much.
Yes.
I'm giving you 5 minutes, Lord. You have finished. For planting that tree, Lord.
Now you can't mention for planting a tree in the Chief Justice Court. You couldn't tell. All right. All right. Before we begin, just a couple of housekeeping announcements for the members of the bar. The space in front of courtroom numbers 1, 2, 3, Chief Justice Court 2, 3, 4, and 5 is being completely air conditioned for the convenience of the members of the bar and the litigants. We've been in touch with some of the most leading agencies in the country who are specialized in that because it's a heritage building. Delhi Urban Arts Commission, the IIT, we have gone to IIT Delhi to ensure that the design is secure, safe. Work is going on. I'd expected that it will be completed by the end of the vacation. It's taking a little longer, maybe a few more, maybe a week or so. There'll be a little inconvenience to the members of the bar. So I request you to please excuse us for the inconvenience and bear with it for about a week or so. We'll be completely air conditioning that so that you don't have to go out of the court and walk into the heat there. So that further is being second. So I request all of you to bear with the inconvenience for a little while. The second, there were 2 waiting rooms just next to the grand staircase which was set up during COVID. I thought that they were really just makeshift and lawyers were using them in very large numbers. So during the vacation, those courtrooms, those 2 waiting rooms have been completely restored. They have been made in a manner which would match with the facade of the Supreme Court. So you can all start using it again and wait for your matters in comfort over there in those 2 rooms. The third, we have now expanded facility for the registrar's court. And there will be a full-time registrar who will be working in that court right from Monday to Friday during court hours instead of having rotations and sporadic assignments for registrars to be in that court. So there'll be a full-time registrar's court. We've just inaugurated the lunchroom for the senior advocates a short while ago. The women's bar room, which was an old standing demand, is almost ready. A smaller facility, but it's almost ready, which I hope will be ready in the next 2 or 3 days. Cubicles for the lawyers, they are also completely ready, and hopefully they will be allocated tomorrow or day after, Tuesday or Wednesday. So a lot of work. We had 42 projects going on in the course of the summer vacation. They're all coming to fruition. The cubicles, I think, in conjunction with the SCBA, will be in a position to hand over tomorrow, Tuesday or Wednesday at the most, but it's completely ready. Yes, now let's get on with the board. But if all the, thank you so much, but if all advocates on record want me to plant a tree, how many trees will I plant? All right. Thank you so much. Thank you. Talk to the Secretary General, all right?
Please, sir. Thank you for accepting.
What should be considered?
It may be considered before lunch. After the road call.
What's the number, Inka? Which serial number is yours?
It's not in the list, Milo.
Then how can I take up a matter which is not in the list?
What
is the matter about?
I'm coming all the way from Kerala, Milo.
From?
Kerala.
It is a fresh matter or after notice matter?
It's a public interest litigation. It's a repetition.
Fresh matter. Is it a new matter?
It's an old matter, Milo.
Which year?
2021.
You should have at least given an email to the registrar. Then he would have taken instruction and listed it. How can we take it? What is the matter about?
Lord, kindly see, my state is flooding like anything.
Your state is?
Flooding like anything. And heavy rain.
Sir, what you do is this. We can't just take out a matter, which is not on board and start hearing it. Just give a, if you, now that you are here in person, talk to Mr. Puneet Sehgal, the Registrar Judicial, and Mr. Pavnesh, Registrar Judicial 1. They will just take stock of the matter and then tell me at lunch. And if there's some urgency, I'll list it. Just meet them both. Yes, check.
Was this matter involved in terms of cheating?
This is for anticipatory bail. It's not a case for anticipatory bail. There's a cryptocurrency fraud. I have a case for regular bail. You can apply for regular bail, but can't give.
Only consider that the whole amount, the alleged cheated amount, has already been deposited before the ballot, and I've not been the beneficiary of this amount.
It's not a case for anticipatory bail. Yes, dismiss.
Because I have to know.
This matter is fantastic for the Allahabad. So it's like undergone 23 months custody. Application pending before the Allahabad High Court?
19 months, Your Lordship, 31 hearings. The issue, 39 hearings. Issue has been made whether foreigners can be granted bail and what are the extra respectful. It is an issue already raised in text.
Issue decide.
Grievance of the petitioner, who has undergone about 23 months of custody, right?
12th will be 24 months. 12th of July.
23, the grievance of the petitioner, who would have undergone 24 months custody on 12 July 2024, is that the application for bail has been adjourned from time to time before the Allahabad High Court and has not been finally disposed of, in spite of 38 listings, you have said?
39.
39 listings before the High Court. Good stop. Since the application for bail is pending before the High Court, we are out of the view that it would not be appropriate for this court to entertain the case on merits. Full stop. However, we request the learned single judge of the Allahabad High Court, before whom the application is pending, take it up with all reasonable dispatch. Full stop. Thereafter, if there is any further delay in the disposal of the application by 31 July 2024, liberty is granted to the petitioner to mention the proceedings before the Honorable Chief Justice of the High Court, so that appropriate directions for early listing can be given. Subject to the above, the petition is disposed of.
Apply.
This is serious. Please. By a writ petition under Article 32, the High Court has remanded the case back. Justice Subramaniam Prasad remanded the case back to the CIC, right?
Yes, my lord. This is not regarding that. The High Court has.
Item number 3, no, Matthew
Yes.
Thomas.
Yes, ma'am.
Same case. So, just the single judge of the Delhi High Court in that RTI proceeding sent it back to the CIC.
Yes, ma'am.
Now you're filing a petition directing the Union of India to halt the use of existing Aadhaar database until measures are implemented.
No, my lord. That petition is regarding. They had not supplied us the complete contract, ma'am. That's why the writ petition was pending.
But this is all at behest of somebody else. It appears that you want contracts of somebody else. It's not a genuine PII.
No, not that, my lord. In the year 2010, ma'am, the second respondent has authorized has awarded these contracts to foreign private entities, which authorizes them to use, store, transfer, collect, and process the data.
But why have you come under 32 here? You can always move a High Court.
We had moved the High Court, my lord, and High Court has granted us the liberty to approach this Honorable Court in the Honorable High Court of Karnataka at Bangalore. Liberty has been granted.
Of the High Court saying that you go under 32.
Yes.
আমি ফ্রাইজ খেয়ে নেব হোয়াট
আজ বন্ধুর বার্থডে সবার জন্য চিকেন সারপ্রাইজ মিল
চিকেন সারপ্রাইজ মিলের সঙ্গে মাত্র 99 রুপিসে পাও বেস্ট ডিল
Sometime, Prasad was in the learned senior counsel, appearing along with the counsel on record, placed for withdrawal of the petition, with liberty to avail appropriate legal remedies, including approaching the Honorable.
No, but you withdrew the petition. You withdrew the petition.
My lord, it was suggested by the Honorable Chief Justice that this matter has to be addressed before the Honorable Apex Court.
But you withdrew the petition. How can we, they have not granted you, I mean, you made a statement that, well, I'll withdraw the petition and I'll either file another petition or move this, or move the High Court. With liberty to avail appropriate legal remedies, including approaching the Honorable Apex Court.
Yes. But it was suggested by the Honorable Chief Justice that since already this matter had been heard in detail in Justice Puttaswamy case, Chief Justice suggested that this issue also be considered by the Honorable Apex Court.
Is that you can get your petition restored before the High Court.
Yes.
Right, and pursue your proceedings before the High Court. If they feel that they can't entertain it, at least pass an order on merits.
Yes.
Then you can challenge the order on merits.
Yes. Can do.
Bench of the High Court of Karnataka in the petition number 17664 of 2021. Full stop. Reading the order, it emerges that the counsel for the petitioner had, after arguing the petition, they sought the withdrawal of the petition with liberty to avail of appropriate legal remedies, including approaching this court, into brackets, that is the Supreme Court, bracket. The division bench granted liberty for withdrawal with liberty as sought. Stop. There is really no occasion for the High Court to grant liberty to the petitioner to move the Supreme Court. Stop. In this view, the matter, learned counsel for the petitioner states that the petitioner may move the High Court for restoration of the petition under Article 226 of the Constitution. We do not express any view on the course of action which is sought to be followed, apart from recording what is being submitted. The petition under Article 32.
May be kept. One small solution. Yes, delay of refiling already delayed.
Ma'am, what kind of a PI to exclude national and state political parties from participating in municipal and panchayat level elections?
My lords, it's a pan-India issue. That's why we have filed the PI.
Another. Yes. What you say may have substance on the ground, but everything that is true on the ground, I mean, where is the legal right? How can we will be creating legislation if you were to allow your petition to bar political parties and conducting the local body elections.
Your Lordship, this
or setting up candidates.
have the role in framing the guidelines to change the ground level scenarios.
It's not something we can assume to ourselves. This is a much broader issue of.
This honorable court can issue the guidelines to frame.
How can we do that? I don't think we can. You can withdraw it and pursue whatever other remedies that you want.
Kindly direct to the decide by representation.
Representation. For changing the law or imposing a bar. What representation? Representation is all right if you are, there's something personal to you that you want the representation to be disposed of. Your service benefits are not provided.
And kindly allow me to withdraw.
So why have you come under Article 32? You are saying our judgment my judgment in Food Corporation of India is not being followed. That is stop people who have invalid caste certificates from getting benefit. But we can't have a general PIL like this.
Issue is about when the similar issue decided by the Honorable High Court. The reasoning given by the High Court is very important.
But the danger, look at it this way. Suppose 200 people in Maharashtra have been given the benefit of protection of their services, notwithstanding that their caste certificates were invalid. We can't just, those people are not parties. We don't know how many people are there.
This is not about the lordships. This is not a personal issue against any individual. This is about the state of Maharashtra government resolution. If the judgment passed by this honorable court, whether the
extraordinarily vague and general. Why don't you move the High Court? Because I'll tell you why. You may also have to implead. If there are, say, specific people, or if you're challenging a geo, you may have to challenge that geo. You have not challenged the geo.
That's what I'm pointing out. Just Lordship, kindly see the page number 123. While deciding the similar issue, what contention decided by the Honorable High Court? Kindly see the page 123. The reasoning given by the High Court of petition.
In some other case?
No, same case. Yes, the issue is about the those persons who failed to approve the caste certificate. They approached to the High Court, and while deciding the same issue, just see the reasoning.
Just 1 second.
Page 123.
What annexure will that be? Annexure? E5?
Yes,
4th of May 21 order of the High Court? Just the
Lordship, kindly turn to the page number 123.
No, just tell us the annexure.
Okay.
Is it P5?
Yes, Lordship. P5.
So internal page 123, right?
Yes.
All right, we got it. Yes.
Yes. Para 24.
Right.
The employer at no stage after the order passed by this court. So earlier, Honorable High Court protected the services of those employees failed to prove the caste certificate, granting protection to the service of the petitioners. Question the judgments of this court and in a way exhibit the said judgment. So according to the court, earlier Honorable High Court protected the services. Therefore, if the government didn't challenge those orders.
So those people see, but perhaps the High Court is right. If the High Court in a given case had protected their services, I know there were a lot of orders like that passed by the Bombay High Court protecting the services. When some matters came up before we set aside those orders, High Court says if you have not challenged those orders, then there is some finality which is attached to the rights of those people also.
But without deciding whether the person whether they failed to prove the caste certificate, even though he can continue the services. This is the issue. Just because of earlier the High Court protected the services, they can continue the services. Just only that's peaceful ground.
Above,
yes.
The government resolution dated 21st December 19 shall be read in a manner not to include the employees whose strike claims are invalidated,
yes,
but are granted protection and employment under the judgments orders of this court, and the such judgments orders have attained finality.
So right now, on cherry on top, what they are doing, they now regularize those employees who failed to prove the caste certificate, and now they are in a list of the promotion. That's the main issue.
But who are you, by the way?
I'm just citizen of India to protecting the rights of the backward community. This is something which is we can't tolerate.
One thing, the danger in such cases is that you are set up by somebody else. Because these people are now going to be promoted. Because you are set up by somebody else to basically challenge in a service matter.
There is nothing is about
you're not even challenging this judgment of the High Court. This judgment of the High Court is not what you are challenging. This judgment is not
party. I'm not a party in this.
You can always challenge it by seeking leave to by permission of the court. So you are now by this side wind really seeking to challenge the judgment of the High Court without including the judgment in this case. How can we do that? And in a PIL, you want whatever protective orders have been passed by the High Court to be certified. A service matter.
I just want to let me clear to thoughts.
And we have also said that judgments of our court saying that in a service matter, a PIL will not be entertainable.
The issue is not about any individual employment. Issue is about if those posts specifically created for the backward community.
No, irrespective of that. You may be right. What on merits, what you are arguing is what my judgment in Food Corporation of India and Bahira's case said. But we had a huge batch of matters which we disposed of, Justice Kehar and myself.
Right. So in a similar way, if the lordship is very clear about the when the person failed to prove the caste certificate, he can't be.
Of us dismissing it, you may be better off withdrawing it because we are not inclined to entertain.
We want to approach to the High
Court. No, we'll not grant any liberty. We said you want to pursue your remedies in accordance with law. That we can record.
Request lordship. Kindly, liberty may given to approach to the High Court.
After arguing the matter, the learned counsel appearing on behalf of the petitioner seeks to withdraw the petition so as to enable the petitioner to pursue appropriate remedies in law, including before the High Court.
This will not affect the merit of the matter.
The petition is accordingly disposed of as withdrawn in terms of the request made before the court.
Highly grateful.
188 days. And he's got the benefit of some leave encashment. Keep the question of law and not entertain the petition.
The last direction of the High Court, Malaj, is not what was prayed for by the petitioner.
Why did you not come? Why do you come with 688 days? There's a delay. There's an unexplained day of 688 days on the part of the state of Karnataka in moving the special petition to stop. The law of limitation equally applies to the state as other parties in a litigation. Therefore, decline to condone the delay. Dismiss the special petition only on that ground.
Grateful.
4 weeks ago. 4 weeks ago.
Pilots leveraging technology for easy access of justice. That is the underlying idea for the system reforms relating to the e-inspection and e-filing.
He says one more. Clarify that this will not stand in the way. We clarify that this order will not stand in the way of the state governments independently taking an appropriate decision, bearing in mind the welfare of the concerned employees.
I may be permitted, Miller, to make my representation to the state.
You can always permit that.
I'm obliged.
you have come after 371 days delay.
21 minutes. Thereafter, the order was made by the Honorable High Court minutes, and we
They have
wanted.
protected 6,000 square meters.
Yes, the minutes kindly consider. In the interganum, the DP got revised 3 times.
You say now that has been reduced from 6,000.
Some other level, different levels. I have a sanction plan from the
concerned. Now what will happen is that the government will reduce the playground from 6,000 to 5,000, 5,000 to 4,000, 4,000 to 6,000.
I am not against that, my lords. Your Lordship gave liberty in the order page 44. In case you agree by the revised plan, you can challenge it to the concerned petitioners. I am concerned with the slum rehabilitation development. The SRA gives me LOI. I pay consideration. I shift some dollars to another place, paying the rent to them for last 3 years, rather 5 years, my lords. Now, in the interganum, the High Court ex parte order, without joining me as a party, grants an interim order saying, Your Lordship says at 6,000. Because I have no quarrel. It is 6,000 or 4,000 or 5,000, but ultimately, today, the entire construction is put to hold. The slum developers.
You were not a party to the proceedings before that.
First time the order was made twice, 2 days I was not party, made a party thereafter.
You are a builder, you know. You can apply for.
I applied thereafter. Kindly consider.
So your IA is pending in the High Court?
I was joined a party by the High Court thereafter. All the authorities have filed affidavits before the High Court pointing out the exact nature of the revised DP, considering
but then the fact that the High Court will dispose of the petition.
It's not being disposed. 21.
Then you have to move.
2021. Kindly see only page 2. Kindly look at my Lord's order. Difficulty. Please see page 2, only for a minute.
We are not going to entertain a petition.
But only one.
When a petition is pending before the High Court.
Minutes, my difficulty.
And after 1 year.
Please see what the High Court says in my request. Kindly see only one page, one line order.
Yes.
Page 2, my lords. I'm sorry to trouble your
So what is the High Court?
Page 2, High Court order, page 2, para 4. One line order.
Right.
One line, the High Court says, my lords, that be that as it may, after considering some matter at the bipartite stage, the order of the apex court directs to maintain an area of 6,000 square meters of the playground. The said order still holds the fate. It is for the parties to take appropriate steps. This is the order made by the High Court after bi-party hearing, after everybody has filed counter before the High Court. High Court today, with all respect.
Suppose 6,000 has been earmarked by the High Court, protected by the High Court.
Because of my Lord's order in the year 1995.
Right.
Now, my Lord's Lordship said.
According to you, thereafter the development plan has been modified, but the area has been restricted.
It has been altered. It was interim order at the interim stage when High Court said that we not change the order.
Look, notwithstanding the Supreme Court order, the development plan is changed now to restrict the area of the playground.
Lordship order was interim order, let me just say. But initially, the area was 8,400.
So that what happened in that petition before the Supreme
Court? That is disposed in 1990.
So point it out to the High Court.
Kindly see page 311.
So what do we do?
The order of the High Court is not available.
1 second. Can we therefore take the writ petition to ourselves and say we hear the dispute?
Suggesting remotely.
So you can move the High Court for expedition.
The first writ petition, PIL, got disposed of in 1997. Order of the High Court is not traceable. Not traceable. I don't know.
All right. The petitioner has instituted a writ petition before the High Court of Telangana. To brackets, what is the writ petition number, ma'am?
Please, Lordship. 20212 of 2019.
20212 of 2019.
Please.
Bracket. Stop. It has been averred in these proceedings that judgment was reserved by a single judge or a division bench. The judgment was reserved on 31 January 2023 by a division bench of the High Court.
Division bench.
Stop. Since the judgment has not been pronounced, the petitioner initially wrote a letter to addressed a communication to the registry of the High Court on 3 April 2024.
Please.
Highlighting the delay in the pronouncement of the judgment, and followed it up with a representation, and followed it up with a communication dated 27 April 2024 to the Chief Justice of the High Court. Stop. The pronouncement of the judgment is still pending. Full stop. We have the view that, bearing in mind the guidelines which have been issued, despite this position, it's been reserved, right?
Please, Lordship. It is there at page 37, showing as pending CAV.
Despite the fact that judgment has been reserved, the grievances that is still awaiting pronouncement. The speeches does it say that it is. Leonard Brothers says that the status which you have annexed doesn't show that it has been reserved.
Lordship, kindly have page 37.
37.
P2.
1 second.
Listing date. It is at from the top. Listing date, case status, pending.
That is the case status you must have uploaded from the site of the High Court. Where is the order? Is this the order?
Even that order, only single order has been uploaded till now, Your Lordship. That is of 2019.
There is no order as such.
Lordship, none of the orders has been uploaded till now, Your Lordship.
Which was the bench? Which was the bench which had heard the matter?
Honorable Justice T. Vinod Kumar and Honorable Justice P. Sri Sudha.
Who did the arguments?
Please, Lordship.
The court must have passed some order.
Yes,
Arguments.
as per the lawyer, we inquired. They said it was reserved for the judgment.
From the record, we do not find any specific order of the High Court reserving judgment. Stop. However, the petitioner has relied on the case status of the matter as reflected on the website of the High Court. We permit the petitioner to move an application before the Registrar General of the High Court, setting out the grievance. Stop. If this is done within a period of 2 weeks, the Registrar General shall place it before the Honorable Chief Justice of the High Court of Telangana. Stop. The Chief Justice may thereafter, on the administrative side, look into the grievance. Thereafter, issue appropriate directions in the event that there is substance in the grievance of the petitioner. The case has been pending judgment despite the judgment having been reserved. The petition is accordingly disposed of.
Lord, what had happened, Manoj? E-auction was allowed. 6 people participated. One of them, the bidder was below the reserved price of 18.4. And that has been given today, despite the fact that 5 others had given it.
Three times the auction was a failure, right?
Just 1 second, Manoj. What had happened is,
now at the third auction, did you also bid?
No, I was not permitted because by the order dated, Manoj, on page 58, by the order dated 30th of April, the court restricted it to OL said that we have withdrawn the earnest money. So was done by the others. And one other person was also not invited. So they invited only 3. 2 of them conveniently, it's a collusive thing, 2 of them conveniently withdrew. And the one who was granted.
But you withdrew your EMD?
So did others also. But they were invited.
Now just give us some facts, because let's understand what date are the auctions taking place. And
I'll give the date, Manoj.
What is the date of the first auction?
Manoj, the e-auction notice is on 15/12, Manoj, and extra P3 on page 36.
1 second. Notice is on 15?
Yes, Manoj.
15/12/23.
Yes, Manoj. The auction was to be held on the 21st and 22nd December, Manoj. Then there was a corrigendum, Manoj.
Yes.
On page 54. And then it was rescheduled for 12/1, Manoj. 12/1/2024.
Then?
Manoj, in this, Manoj, L1 bidder was, Manoj, at 25.24, sharp steel, Manoj. there was another, my lord, this is on page L, my lord, in the synopsis, my lord. The 5 bidders, my lord.
Now, you participated in the auction.
Yes, my lord.
And you bid at 23.44, right?
Yes, my lord. And I was the third.
You are the L3.
L3.
Right.
So, my lord, what has happened now is, I was L4, my lord. I was L4.
Now, what happened in that first auction?
Lords, when my lord, the auction was to be finalized, my lord, the successful
bidders withdrew,
saying that there are complications. I did not know of the difficulty.
Right.
So he withdrew.
So the first auction was cancelled.
Yes, my lord.
All right. We'll proceed step by step. Then second auction takes place.
My lord, this is where the problem is. For second auction, the court itself, my lords, finds 3 bidders, and that is on page, my lords. This
That
is
the order of 30th of April 24.
30th of April 2024 on page 57.
Just 1 second. We'll see
this is where we were not. OL and other parties were there. The necessary parties to the winding up, my lords. And now this is, I will read, my lord, the second paragraph. The official liquidator shall, within a week of communication of this order, convene and hold a fresh auction inviting 3 bidders. Sharp Steel, the one who did not, my lords, he was an L1, did not, my lords, took it, was invited again. Then is, my lord, Square 4. Square 4 is the one who did not, cannot be called a bidder because he bid less than the reserve price. And Avirock is the one who withdrew his EMD 1 month prior to mine, my lord. So, all 3 actually are defaulters.
Annexure P, 30th, yeah, I got it, P5.
This is on P5, page 58 is the relevant part, my lord.
See, the official liquidator, just read that order again.
Yes, the official liquidator shall, within a week of communication of this order, convene and hold a fresh auction inviting 3 bidders with Sharp Steel Industries, Square 4 Logistics and Avirock meeting. Sharp Steel is the one who was successful. He was the L1 bidder, did not take it. 2, Square 4 is the one who did not bid even the reserve price. So it cannot be called a bidder in the first. Avirock is the one who withdrew its EMD even prior to mine, my lord, 1 month prior to me. But they were called, my lord, indiscriminately on the suggestion of OL.
Now, did you challenge this order?
Yes, my lord, I challenged this order, my lord.
Where?
No, my lord, this order, actually, my lord, we did not know. I was not a party. So I challenged it in an IA.
Was not a part.
We challenged 16th May order, my lord, which is...
He filed a recalling application.
On respect of this 30th April order.
16th May. For 16th May order.
Where is the 16th May order?
When is impugned order, my lord, in this?
16th May is not the impugned order. It's page 57 is the 16th May order.
My lord, that is, he is reading the other writ. My lords have 2 SLPs.
It's 37, my lord.
2 SLPs and 1
May. The first matter, 16th May order is the impugned order.
Okay, that's
right. Right?
Yes, my lord. So 16th, my lords, please see the 16th May order, which is, my lords, the impugned here. I have supposed to, otherwise, because I had challenged this order in IA.
Who is your client, by the way?
My client is Shiv Shakti, the person who provides us security services. My appeal was before the appeal court, and my lords, if my lords see the 16th May order,
are you willing to deposit 23 crores here in our court? Are you willing to stand by your offer of 20? Your case is that you are offering 23 crores.
At that time, yes, my lord.
The offer which has been accepted is of 18 crores.
My lords,
are you willing to deposit 23 crores?
I am ready to deposit right now, my lords, over a period of time, which time will be given 20 crores to start with, my lords. Why I am saying, my lord, it will be 2, my lords. This person.
Look, you have a higher offer.
My lord.
1 second. We want to test your bona fides. Yes. Otherwise, what happens in all these auctions, somebody will find...
I will deposit, my lord. Why? I'm saying 20 crores. When this auction happened, my lord, and when these people were withdrawing, there were certain, my lords, liabilities which were not known. That is why people withdrew. I'm saying I'm still higher bidder, my lords. I'm ready to give 20 crores. It is 2 crores more today. Because this is, I was not invited. I would have given 2 crores plus.
Why did the court restrict the auction only to 3 parties? Who are you appearing for?
I appear for the secured creditor. What happened was, first application was by the secured creditor for a private sale, because sale was not happening at all in this. Therefore, initial application was for a private sale for 18 crores. Thereafter, the court again give one more option for auction. Then this auction happened.
But the auction, why did the court restrict the auction only to 3 parties?
Because other two had gone. That time, this gentleman had withdrawn his EMD.
But the other person who was one of the 3 who participated, who was allowed to participate, he also had withdrawn his EMD. That's
Later, my lords.
No, 1 month prior to
my lords,
just 1 month prior to him, that man had Agoric, no? Agoric.
Yes, madam.
I was in item 37.
29-1. I did on 29-2.
My lords may see page number 57 in item 37, annexure P5, that 16th May order.
Yes.
My lords, Sharp Steel, the main party, withdrew its offer bid is letter dated 6th May 2024.
No. My lords are not talking about Iberic, my lords.
And my lords, in the same paragraph, page 59, where my learned friend is appearing, there was a joint lenders meeting in which this private party was approved as a buyer.
We will issue notice here. I think we'll issue notice here. We'll issue notice here. And who is the successful bidder? Is he a party here?
Yes, my lord.